Hello, I hope everyone is doing well. This is the Small Entrepreneur and Economic Development Legal Clinic at the University of Akron, and today we have some materials about a partnership agreement. So before we get started with the partnership materials, we just wanted to have a quick disclaimer that these files were created and reviewed by students under the supervision of a licensed attorney here at Akron Law. These community resources were designed to educate and inform entrepreneurs and early stage startup businesses. With that being said, they may omit terms or language relevant to specific situations and circumstances. Although the Seed Clinic does take reasonable efforts to update its resources and to provide current information, this PowerPoint, the templates, and any other information by the Seed Clinic is not legal advice and is not guaranteed to be complete or current. Any use of these resources does not create an attorney-client relationship between its users and the Seed Clinic, nor does it constitute any sort of legal or professional advice. It is advised to consult with a licensed attorney before using any of these materials and forms, and the user of the forms and resources assumes all risk and liability that may result from such use. So before we can get into what a partnership agreement is, what it does, and what does it entail, we have to take a step back and first ask, what is a partnership? So, a general partnership occurs when two or more persons carry on as co-owners of a business for profit. This can be formed in several ways. It can be formed orally, it could be formed in a written contract, it could even be done through action. And it's important to note that such action doesn't even have to be intentional. So, for example, Ben and Jane, although they never formally agreed upon, whether orally or written, they decide to open a restaurant together, and each contribute to the operations of opening the restaurant. As soon as both Ben and Jane contribute to the operations of opening the restaurant, a partnership was formed because they are going into business for profit together. So there may be some questions as to why should I go with a partnership over an LLC or a corporation or another type of business entity structure. There are a number of reasons why to form a general partnership, and some of them are included here. So the first we have is it is relatively easy and inexpensive to form. Most states do not require registration to form a general partnership. So kind of in the last slide I was talking about partnership could be formed through action. So the example with Ben and Jane, as soon as they decide to go into business together and contribute to the restaurant, that is when a partnership is formed. Whereas an LLC or corporation, you have to have filings with the Secretary of State, and there's costs associated with that. Further, there are fewer or almost no administrative requirements, again, compared to a corporation, for example, which they are required to, have a board and or to hold annual meetings and a bunch of other administrative requirements. Whereas in a partnership, there is none of that. You just conduct business for profit, unless you choose to do so. And then finally, it is tax friendly. Generally, partnerships do not pay state or federal income tax. The partners instead pay taxes on their share of the partnership's income at their personal income tax rate. So with the positive characteristics of a general partnership just discussed, a lot of people may be thinking that a general partnership is the absolute 100% best way to go. They're thinking, yeah, it is relatively easy and inexpensive to form. There's no administrative requirements. It is very tax friendly, so on and so forth. Now, all these things are true, but there are a couple of things to consider when forming a general partnership. So the first is under a general partnership, each partner is personally liable for any debts incurred by the partnership. So say, for example, Ben by himself takes out a loan on behalf of the general partnership formed between him and Jane. Now, even though Ben was the sole actor in this situation, he took the loan out on behalf of the partnership. Therefore, Ben and Jane are both going to be liable for the loan. Another thing to consider is that although a general partnership is a legal entity distinct from its partners, partners are generally individually and jointly responsible for any liabilities incurred by the partnership. So say at Ben and Jane's restaurant a customer comes in, slips and falls, and is injured. They go to court and they end up winning. Ben and Jane are going to both be liable for any damages that the customer may recover because of the nature of the general partnership, of the fact that every partner is individually and jointly responsible for any liabilities incurred. So now that you are aware of some of the potential setbacks to a general partnership, you may be wondering, is there any way to mitigate these things or to prevent such liability from occurring? And there is, and the best way to do so is to form a partnership agreement. So similar to any other agreement, a partnership agreement is an agreement between parties. The parties in this agreement are going to be any and all partners that are considered to be owners of the business. So with Ben and Jane owning a restaurant together, they were going to form a partnership agreement. Those will be the parties in that specific example. Now, any partner who joins after the agreement has been executed typically is still going to be bound by the original partnership agreement. And of course, you are able to amend the partnership agreement whenever the partners see fit. So it is not necessarily the end all once the partnership agreement is first executed. So now that we have identified the parties to a partnership agreement, it is time to ask, what is a partnership agreement? A partnership agreement is pretty self-explanatory. It governs the relations among partners and the operation of the partnership. It can be very extensive, very detailed, very thorough, or it can cover just the necessities. It comes down to what the partners feel is best for business needs and what they feel comfortable putting to writing. So some typical subjects that are generally addressed when it comes to an agreement include the identification of initial partners, any required initial capital contribution, later requirements of additional capital contributions, and the consequences of failing to contribute when those deadlines are due, the allocation of profit and losses for tax and accounting purposes, provisions for removal and replacement of the partners, so whenever they want to sell their partnerships or they want to be bought out, so on and so forth, the powers and limitations of the partners, what can one partner do that the other can't, or what can all partners do, and then finally the procedures for dissolution, which means the ending of the partnership. So a partnership agreement, similar to any other sort of agreement, is very thought out, very meticulous, very thorough, and takes some time to produce. And you may be thinking, do I really need a partnership agreement to get a partnership off the ground? And although many states allowed these general partnerships to operate orally and thus not require a written agreement, it is still good practice to have one. This, keeps the ideas that were originally agreed upon because it is in writing. It defines the roles and what everyone is expected to do. It keeps everything exact. And with that in mind, it is important that the partners decide which provisions should be included in the agreement, especially ones that are consistent with the fundamental needs and objectives of the partnership. So when you're looking at templates, or you go online, or you have someone draft one for you, it's important to have clauses that are meaningful, not ones that you're not necessarily going to not use. So for example, you do not need a clause about meetings if you do not plan to hold meetings, right? And with that being said, you should still include the standard boilerplate clauses for best protections, which we have a presentation on, and you should definitely check out. And one final note is any issue relating to the partnership that is not covered in a partnership agreement will default to statutory law for resolution. And this is just saying, it's not the end of the world if it's not discussed upon in the partnership agreement. There are laws in place that they will rely on, but if you would like to have it play out a different way, it is, imperative that you put it in the partnership agreement. Otherwise, it will result to the standard law. So we definitely covered a lot of information regarding partnerships and the partnership agreements. So we wanted to give a couple of final notes about the template that the Seed Clinic has provided. The first is that anywhere in the agreement that is highlighted is intended to have specific information by that specific business. So the partners are going to have to come together and decide what exactly they want that area of the agreement to say. And with this in mind, it is also important to review any and all clauses to ensure that they fit with the needs and objectives of the partnership. Similar to what we discussed earlier about not having a clause about meetings, if you're never going to hold meetings, it's important to review that to ensure that the agreement has what is important to the business. And then finally, for any specific advice or questions, it is imperative that you seek individual counsel, as the Seed Clinic is not providing any individual advice or specific advice to the business, its partners, or any of the like. We hope you find this information useful, and thank you for tuning in.